We record this webinar this afternoon and make it available on Facebook as well as our website for those who are not able to join us live. We are also live streaming on Facebook. I would encourage you, if you are joining us on Facebook, to please use the question and answer box on Facebook and we will get your questions answered. If you are joining us on Zoom, please use the chat box or the question and answer section to join to ask questions on the Zoom platform. And with that, I am going to turn this over to Ben Jones, an attorney with Disability Rights Maine. Thanks for joining us, Ben.
Thanks, Carrie. It's always good to be here. Just as a precursor, these webinars are set up for families, parents, kids, anybody that's going to be advocating for students with disabilities. So I know we have lots of other people, we always do, especially in Zoom days, but that is the intended audience. So if you need your own advice or information, I'd recommend seeking it from a different source. So let's get started. Keeping all Maine students safe. So this title is an homage to the federal legislation that's working its way now. That's a current bill called Keeping All Students Safe Act. And the new legislation in Maine that has now become law was modeled after that, and much of the language is the same. And the hope is that this would become federal law eventually. People are trying very hard. But in the very least, we have it in Maine now, so that's great news. Let me make sure this works well here. Clicking next, there we go. So this is my contact info. Like Carrie said, please just pepper questions in the chat. I think that's really maybe the only way that you can reach us since everybody's muted. But that's really helpful too. So somebody's saying they cannot see me. Do I need to pin myself, Carrie, or something like that? I'll let you and Dylan work on that. Oh, somebody else said they can.
Yeah, and I just pinned you, Ben. And
okay.
Susan, you might need to pin Ben yourself as well. If you go to the three dots, you can do that. But Ben, you have been pinned on my end. Sorry about that.
Okay, no, that's okay. I won't be able to really review the chats. Carrie's going to take care of that, but I just saw that, so I'm glad everybody is with us. So this is my contact info. Like I was saying, send questions in now, right when you've got them and they're relevant to the presentation, and Carrie will jump in. Or we'll pick up some at the end as well. We've left time for that. But you can always just send me an email. And if it's about an individual issue, about an individual kid, please go ahead and send it through our intake process. Like with all the organizations, we have to screen it just to make sure it's something we can help with. And then you get to me. So this is just disclaimer. This is not legal advice. This is information and resources. Like I said, if you have a specific legal issue for a student, please contact us, our office. You can also reach out to Maine Parent Federation. They have a great parent navigator program, and they have lots of information to share as well. So I think Carrie said this at the beginning, but we're going to keep it pretty tight. We're going to keep it to an hour. And I've tried to winnow it down just to the core pieces. So there's more to say about the new law and what it means and all kinds of things, but this is really the core piece. So it's not exhaustive. And here's a quick overview. So we'll break it down into four parts. So restraint and seclusion in Maine schools, generally, just talking about the state of things in Maine. The new law, so the reason probably most people came, what's different, what's changed. Proposed amendments to Chapter 33, so folks that are aware of restraint and seclusion and the rules and laws that apply. The current state of things is called Chapter 33, and then this new law is laid on top of that. So I'll talk about what that means, how those interact. And there's proposed amendments out now from the DOE, which are going through the rulemaking process. And then just some general resources about supporting your student, the kiddo that you're thinking of when you come here. And I think Carrie introduced me, but again, Ben Jones, Disability Rights Maine, managing our education practice here. So why do we see frequent attention on restraint and seclusion in schools, nationally and also especially in Maine? Well, Maine is unique in a not so great way in the fact that we are the #1 highest user of restraints per capita in the United States. And we're the second highest user of seclusions in the country. And so the reason why we have this data is because every 2 years, the US Department of Education requires public schools to send in their restraint and seclusion data, similar to the Chapter 33 data we have for the state. And so we're able to compare state by state, and Maine is #1 for restraints and #2 for seclusion. So an issue to be fixed, to be addressed. A little bit more on Maine's data. So now switching over to the Chapter 33 data, the data that we have within Maine. And the rates keep going, I mean, the use of restraint seclusion keeps going up, and it's gone up for most every year that there's been a record. The recording started in 2013, and that was relatively high. It went back to a certain level in 2014 and then steadily rose to 2019. I'm not going to talk too much about 2020 and 2021 data just because COVID messes with that, and it's better to have that long view. But I do have that data, and you can certainly look it up. The short story is that they did go down a little bit, and the guess would be that less kids were in school, remote learning during that time. So how many are we talking about here? How many restraints and seclusions? Well, over 22,000 were recorded by DOE back in 2019, the last full school year. And it's really likely that those are much higher. I know some folks talk about the reliability of that data. From what we review, from student records and what we've seen through investigations that we've done at schools, a lot of restraints and seclusions are not recorded. And there's many more than that than would be doubly recorded. So it's likely much higher than even that 22,000. Just a brief graphic just to show that same idea. Data started in 2013, was at a certain level around 16,000, kind of reset to a certain base, and then it's just steadily grown every year, unfortunately. And for our purposes, for the kids that we are focused on here at Maine Parent Federation and DRM, students with disabilities are affected by far the most by these. So in Maine, students with disabilities, DOE folks might have the most accurate information on this, but it's right around 20% of students in Maine have a disability. I think it's 19 and change %, but they make up more than 90% of the restraints and seclusions. And again, that data is drawn from the federal data, because so far the Chapter 33 data has not broken down by disability. And that's a change under the new law. So we'll be able to see that more specific to Maine. But for the data that we have, over 90% of restraints and seclusions are used on students with disabilities. And there's clear consensus that these things don't work, insofar as people might be hoping that using restraint or seclusion is going to address the behavior that's an issue. That's all untrue. There's no data to back that up. And in fact, it can have very serious consequences. People might see the national news once in a while on this, but multiple students have died during restraints and seclusions. There's been suicides in seclusion. It's just really, really dangerous activity. And so the intent for Maine is to just limit it to the point where it's only necessary, and we don't have any of these unnecessary restraints and seclusions, because it's certainly true that there's no way there's 22,000 emergencies every year in school. From the incident reports that I read, oftentimes it's from a kiddo throwing a pencil to a staff creating the emergency by approaching a student, and there's lots of more effective ways to address the behavior of concern. And it's just another source to show that there's a consensus that these things do not work and are dangerous. Also, Chapter 33 itself, which this piece hasn't changed under the proposed amendments, acknowledges that these things are only for emergencies. So restraint and seclusion is only allowed to be used for emergencies. They cannot be for therapy or for educational purpose, and they can't be used for punitive purposes or staff convenience or to control challenging behavior, only for emergencies. Okay, so that's an overview of just the state of things in Maine. A little bit shocking if you haven't seen those before. I know I've just lived in this data in this world for so long, I might get a little tired of it, but it is shocking. It's 22,000 plus restraints and seclusions. It's really appalling. So what has the state done about it? What has the voters said about this? And do we have new protections? Yes, we do. So the new law, I'm referring to it as LD 1373 / section 4014. Not a very exciting name, but that's just to capture, in case folks only knew it as the LD, meaning the bill that people were working on, or the new section, the proposed section of the law, 4014. So I'll say it's 1373 from here out, just for shorthand. Okay, so what is in the new law? Well, there's new definitions. So definitions are everything, really, and that's going to be in the first section of the law and likely the first section of any amended Chapter 33 rules. And so let's go over those kind of core changes of the definitions. So physical restraint, that term's still the same, but the definition is different. So physical restraint now means a personal restriction that immobilizes or reduces the ability of a student to move the arms, legs, or head freely. So that's not a huge departure from the old definition I put down at the bottom here. I'm calling them the outdated definition. I didn't want to say Chapter 33 because it's still live. We'll explain that a little bit later. But so the outdated definition is intervention that restricts students' freedom of movement or normal access to his or her body. So those don't sound too far apart from me. And the piece that does remain the same too is that these explicit exclusions, so physical escorts, physical prompts, mechanical restraints, or chemical restraints are not physical restraint. That doesn't mean that all those things are allowed. It just means under this term, physical restraint, those things are going to be defined on their own at another section. I'll pause 1 second just because we've hit a big definition moment, and I'm looking at Carrie, and I think I can
So, yeah, thank you. We did have a question a little bit earlier, and I told
Sure.
the individual that you were going to cover it, but this is the perfect time to cover it. She was wondering if we expect restraint and seclusion to skyrocket. She's under the understanding that standing in a doorway preventing a child from leaving a room for more than 3 seconds is going to count as a restraint.
Standing in front of a door and the student's alone
So
inside.
she didn't say alone. She
Didn't
just
say
said
alone. Okay.
standing in a doorway preventing a child from leaving a room for more than 3 seconds is a restraint.
Okay. Well, I can say that example doesn't come into here. I mean, that doesn't, like, okay, let me say, no, that's not a restraint under the new law. And it will be helpful just to understand. If anything, that would get close to a seclusion. And if that student is alone in that room and they are physically denied an exit. So this, again, the seclusion definition is not that much different than the old one. So under both, I think what the person's mentioning, if the student's alone, that would be a seclusion. So the new definition of seclusion is involuntary.
Can I just,
oh yeah,
before you jump into that, can we just go
Yeah.
back to the restraint? Because part of the restraint definition is, but the student would not be able to move freely. And so in the circumstance that that individual gave us, the student wasn't able to move freely. The student wasn't able to exit the room.
yeah.
You're not holding that child, they're able to move freely within that room. Is that the difference, Ben?
Sure. That might be getting down too much into the weeds. You know, at some point, this is going to be more clarified by the proposed rules, the proposed updates to Chapter 33. But as it is now, physical restraint, the intent and the writing of it is it's a personal restriction that's immobilizing a student's ability to move their arms, legs, or so it's specific about parts of the body. So I would be surprised if that would be considered a restraint. If it's based
And then,
on,
and I know we're going to cover this, but somebody just mentioned the example of blocking. So for example, they were told that if a student wants to punch you and you stop them from or prevent them from punching, that's restricting them, their ability to move freely, and is a Chapter 33 restraint.
Well, that's going to be clarified more in the Chapter 33 proposed amendments. So as I read it, I think that the exception that the DOE is proposing makes sense. It says it defines deflection, which I'll get to. And so I don't want to misremember the exact definition, so I'll get to it. But essentially, the deflection will be an exception in the sense that you can divert somebody's movement or break up folks, and it's not considered a physical restraint. So that should cover that. Go ahead. Is there anything?
Great. Yeah, and then so then there's some questions about what's an emergency. Like if a child is pushing their body into a staff but not open or closed hand hitting, is that an emergency? And then we just cover that. I can't locate the other question, but there was another question that was addressing, definition of emergency. So
Sure.
Oh, yeah, I'm curious about the definition of emergency to justify a seclusion. So those were the two emergency questions.
Got it. Some of that will be clarified just as we go through, because I'm going to compare the new law in Chapter 33 and a bit about the proposed amendments. So I hope it's clarified further, but please bring those back, if it doesn't happen at the end.
Okay.
But the short version is that there's more to be defined, and Chapter 33 amendments are going to do a lot of that defining, and I don't have control over those things. DRM is going to submit their own comments about it, and I'm sure Maine Parent Federation will as well, and families can do so if they like. But that will be ultimately the consensus definitions. So right now I'm just sticking to what's in the law, not what's in the new rules that will be sometime in the future. So we're just focused on the new law definitions. Okay, so we're done. Okay, now we're on to seclusion. So hopefully this highlights for the person if they're also curious about seclusion. So involuntary isolation. So against one's will, isolated, alone, clearly defined area. So it doesn't have to be a room. It could be the corner of a room. It could be some other defined area that the student doesn't feel free to go or can't physically exit. So where I thought that the question was going is standing in a doorway, is that the same as holding the door closed? The answer is yes. Those would both be seclusion. And there was lack of clarity on that under Chapter 33 for some schools and entities that didn't record that accurately. And so this makes it clear if the student doesn't feel free to go. So that's the new piece of this. So again, I put the outdated definition just to show that they're close, but slight change.
So Ben, if a student
Yes.
is left alone and the teacher remains in the room, then that's not considered seclusion because they're not alone, correct?
Correct. Yep. You have to be alone to be secluded. And then the law breaks down what's permitted, what's allowed to be done, and what's not allowed to be done, and uses the term unlawful. So I've used that as a header for these next sections. So what is unlawful? Restraint and seclusion. Mechanical restraint, which is defined, which was already unlawful. And the new law also spells out the clear exception for seat belts and safety harnesses and those other types of devices. Chemical restraint, there's a new definition for that, but the meaning is the same. Before it just talked about PRNs, and now it's more expansive to say a non-prescribed use of a chemical. And so those are still unlawful. Also unlawful is physical restraint or physical escort that is life-threatening, restricts breathing or restricts blood flow to the brain, including prone restraint. So folks might be aware of the term prone restraint from the news, from national news, to do with law enforcement or to do with Long Creek recently. Prone restraint is you're down on your stomach and you're being held as such in a prone position. It's called a prone position. So those are inherently dangerous. And then this is a particular highlight for students with disabilities, which is that restraint and seclusion is not allowed if it's contraindicated based on a student's disability or healthcare needs as documented. So that can be documented in a healthcare directive or a behavior intervention plan or the IEP or a 504 or an ADA plan. So if so for example, if the IEP team agrees and says, this student who has PTSD should never be secluded. It would be traumatizing for them. We don't think it's something that should be done. They can say that, and that would protect that student from being secluded. Okay, I'm going to pause.
Pause for a minute.
Yes.
So these new laws apply to Long Creek.
Good question. No, they don't.
Okay.
That's a different setting altogether, and different rules apply under DOC. And so the thing that does apply to Long Creek is IDEA, which is ensuring that students have a free, appropriate public education. And so those are tools if you're advocating for a student that's in there. Okay. Those are tools you can use, having an appropriate program. Restraint and seclusion might come up as a part of that, but no, these would not apply to Long Creek. It's a good question.
Do mechanical devices that are used for safety or positioning need to be prescribed by an authorized practitioner at this point?
That's a good question. It doesn't say so in the law. I think that's likely a good thing to do. That would make it abundantly clear, if a parent is planning on pre-advocating, to make sure that their kiddo is safe at school, they might want to send that ahead of time and say, by the way, my kiddo is going to be using a mechanical restraint. Here's the prescription. The directive for it. So no, it doesn't say explicitly.
Do we have a definition of life-threatening?
No. A lot of the terms aren't defined. Like with any law, they pick the highlight, the terms that seem to be the most important or relevant to, but at the end of the day, it's just how the law was written. And so I think the hope is that any rulemaking, like I said, Chapter 33 is under current rulemaking. The hope would be that things will be more explicitly defined there. And if people have ideas about what that should be, they should submit their own thoughts.
Just to be clear, we're getting another question about seclusion. If a child is not left alone in the room, it's not considered seclusion. So if there's a teacher in the room with the child, then they are not being secluded. A child has to be left alone in the room and not have the ability to leave the room, being prevented from leaving the room to be considered seclusion. And then does Maine include the imminent serious physical harm standard?
Say the last part again, Carrie, sorry.
So does Maine include the imminent serious physical harm standard?
Does Maine include it?
Yeah.
Meaning, is it in the new law? That is the new standard for the law. If the question is it defined, again, that's going to be Chapter 33 that's going to put meat on the bones of the specific definition. So there's some of those have been defined, some not. And that's going to be the work of the rulemaking, really. So, okay, let me forward, Carrie, let me just forward you.
Yeah, go ahead.
And we can save a few, just because this is awesome. I love having the questions. It makes it lively, but I just do want to get through a little bit more. And then I'm sure there'll be more questions too. So when is it permitted? So we talked about unlawful restraint or seclusion, many of which are similar to before. And then what has the new law added to that? And this is the standard right here. So the standard used to be risk of injury or harm to self or others. And now it's imminent danger of serious physical injury to student or other person. So again, that's going to be defined in the rulemaking. It's not defined by the law itself, which is, I think, by design. I think it's meant to be a collaborative effort. Less restrictive interventions would be ineffective. That's a holdover that was in Chapter 33 prior to physical restraint. Ends immediately upon cessation of the immediate danger. That's the same, except for the standard being different. And the least amount of force necessary is used. Something similar to that was in Chapter 33, but it's more explicit in there. Okay. Oh, this is, okay, this one's called outdated definitions permitted use. So I previewed this, but under Chapter 33 and under the previous, before the new law, it was still only allowed to be used for emergencies, risk of injury or harm, less intrusive measures have failed or deemed inappropriate, and end as soon as possible. Okay, and I'll go two quick other definitions, then we'll go back to some questions. So escort and prompt, those have always been exceptions and are not included in the definition of physical restraint. That continues under the new law. And the only substantive change is that the word voluntary is added in to escort and prompt. And it's really not a big change. In fact, it might look like it, but it's not a big change in fact, because physical restraint always was considered, including at the bottom here, includes physically moving a student who's not moved voluntarily. So previously, physical escort, if it was involuntary, was a restraint. It wasn't recorded as such all too often, and so people misread that. And also some of the training programs that implement restraint or seclusion use similar terms, but they don't line up perfectly with the law. So when in doubt, the default is to go to the law as opposed to the training program, of course. So that's just made that's made more explicit by putting that word voluntary to prompt and escort.
So Ben, if it's
Go ahead, yeah.
with a physical therapist and a physical therapist is guiding their movements and the child resists the movement, is that considered a restraint?
I guess it would depend on what it means by resisting. If
Let's just say they were stretching the child and the child pulls back from the stretch because it's uncomfortable.
Yeah, I don't know.
Okay.
I mean, those things are going to have to be figured out on the ground, but I think I can focus on what the law says and a little bit about the intent, which is that before students were being escorted, and that was being called an escort and an exception when it should have been a restraint. And the point is that if it's restrictive and it's against somebody's will, it's a restraint, you got to write it up. And it has to be up to the standard, versus if it's just easing somebody on their back to get them going a certain way or giving them a quick tug in a certain direction, those things are contemplated by escort and prompt. So they've always been supposed to be voluntary, and now they still are.
Okay. So looking for a little bit more clarity on using the word voluntary, particularly with regarding to prompting. For example, if a student did not want to engage in a necessary hygiene task, then the prompting would not be voluntary. A prompt under 1373 must be voluntary, and prompting them through it would restrict to at least some extent the free movement of parts of their body. Thus, it would meet the definition of unlawful restraint.
I'm going to just stop this line of questions because it sounds too much like these are providers and schools asking the extent of that they can restrain or seclude, or that they have to, and this is really meant to be for families. So the intent is that families of students with disabilities have greater protections under this law, and it's incredibly important. Students in Maine are manhandled more than any other place. And so these protections are highly important. And I encourage any family to reach out to me if their students experiencing unnecessary restraint or seclusion. It could be against their federal and state rights. So please reach out to me, families. And I'm just gonna, I'm gonna just kind of veer back towards the parent focus. I hope that's
I just
okay.
want to be clear, hand over hand prompts. So when you're doing, I mean, that's a common practice, hand over hand, that is not considered restraint, correct?
I wouldn't consider it that.
Okay.
Yeah.
Does staff need to be trained in physical restraint before getting involved?
Yes, the proposed amendments to DOE is written the same way for staff training, in the sense that you must have staff trained to use restraint or seclusion if it's going to be used. And if it happens in such an emergency fashion that nobody can get there in time, somebody who's untrained can be there for as little as time as necessary to get somebody else there. So that continues on from chapter 33. Should I forge ahead?
Yep, keep going.
Okay. Some other highlights from the new law, which is reporting and technical assistance. So this was an important piece for folks that supported this, because it provides the Department of Education some directive to support schools if they're concerned about how they're going to support kids after this. And that is, well, first of all, reporting. Reporting was always a part of it. The big highlight there is that it's going to be broken down by disability, just like the federal data. So we'll be able to see how this is affecting students with disabilities more specifically. And then the technical assistance, there's quite a bit in there. It's within the DOE's existing resources. So they have folks that are focused on positive behavior supports already, and I've put some of the resources at the end. But they're in charge of developing, implementing, and providing technical assistance to schools, focused on evidence-based programs, trying to reduce the behavior that leads to restraint and seclusion, reduce the need for restraint and seclusion. So lots of good stuff in there for schools to reach out. And I know DOE is working on it right now as well to put together some of those resources. Okay, so I've highlighted this a few times, but just to be clear about the status of chapter 33 as we know it today versus tomorrow versus after there's new rules. So chapter 33 exists today. That hasn't changed. What's changed is that any of the new definitions and anything in the new law that conflicts with chapter 33 is superseded by the new law. So like I highlighted, the definition of restraint, that's just supplanted. You know, that's changed. And that rulemaking process will make it all more clear. And people that have looked at the, I see Sarah put in the link for PBIS. I have that one at the end too. Thanks, Sarah. Essentially, that should be clarified in the rulemaking process. But just to highlight other things that haven't changed, that have always been protections and requirements. All students in schools are covered, whether you're funded or contracted. No physical restraint or seclusion for property destruction unless it's that level, that risk level. Exceptions for timeout, which is a direct, it's defined. Student is directed to go to a timeout. That's not a seclusion or restraint. Staff have to be trained. There has to be debriefing with the student and with the staff after any use of restraint and seclusion. Incident reports, which is to record what happened, and notice it to the family within 24 hours and then in writing within a week. And local and state complaint procedures. So every school has to have a local complaint procedure. And then if the family's not satisfied with the result of that, they can go to the state and say, please review this as well. So those things, as I read it, still exist. And under the proposed chapter 33 amendments, it looks like DOE is also acknowledging that a lot of these things just continue on.
Do we have a definition for timeout yet?
We do. I don't know as I included it. It's the same as before. It hasn't changed. Let me just, because I'm sitting right here with everything in front of me. Timeout means an intervention where a student requests or complies with an adult request for a break, and it's not seclusion.
Thank you.
Yeah. Okay. we're at another good breaking point. I know you just had some questions, so just wanted to catch up. Any others?
Somebody gave, I answered this in the question and answer, but picking up a child against their will, would that be considered a restraint?
Yes.
Thank you. Somebody mentioned about, what if the hand over hand causes bruising? I would just say if you have to apply that much pressure for hand over hand, that probably is not voluntary.
Yes, that makes sense. Yep.
I think that's for right now.
Okay.
Yeah.
Great. Okay, so that's highlights from the new law and some comparisons to the old definitions. And I kept mentioning this, so I wanted to include it as well, which is the DOE has released their proposed amendments to Chapter 33. And my understanding is that it's going to be the same name. It's all going to be still Chapter 33. It's just going to be updated to include the new definitions. And there's going to be some specifics that have to be figured out because the law didn't define every single word, and Chapter 33 doesn't define every single word. And so that will be worked out through the rulemaking process. And I defer to Carrie and other groups to fill you in if you want to reach out to see how you can get involved in that process. But
I did put the link to the new language from the MDOE website in the chat.
okay.
I'd also let people know that the public hearing is on November 22nd and the public comment period ends on December 3rd.
Okay. So just to highlight this, the DOE is very clear about the status of Chapter 33, but you can go to the website and see for yourself. The current Chapter 33 rule is in effect to the extent that it doesn't conflict with the new statute. Existing resource and guidances, so DOE's put out FAQs in the past, and they've put out other responses. Those things are not updated. So there's a warning about those on the website to say these are potentially out of date. And that's when it says APA, that's the Administrative Procedures Act process. So rule making, that's what's happening right now. And I put in the link here in case that wasn't already around, but that's the proposed amendments in the schedule for it.
Restraint seclusion reporting can be found on the data warehouse, correct? MDOE's data warehouse?
That's right. Yep. It used to be just under the restraint seclusion webpage, and now it's in the general data warehouse under student behavior, I believe. That's the headline. Just one, I wanted to highlight this because somebody already asked and other folks have been curious, but the proposed amendments to Chapter 33 does include a definition for deflection, which wouldn't be a restraint. And that's defined as an intervention where the movement of a student is momentarily diverted because the student's movement would be harmful or dangerous to the student or others. So I'm guessing that's an effort by DOE to propose a definition that folks were concerned that they wouldn't be able to do blocking and deflecting things that were permitted before. Sounds like they will be.
And if a student is grabbed, like say they're going to run out into a parking lot or run in front of a swinging swing and the teacher just grabs them to prevent injury, is that considered restraint?
Well, I guess it matters what I thought you might say a school bus, because that one comes up so often.
Somebody used the swing, the swing at the playground, which can be very common, and I know schools have parking lots that can get busy as well. So
sure. It's really going to have to fit within these definitions. It's too hard to imagine every possible hypothetical. It certainly makes sense to me that if a kid is running out of the school into a dangerous situation, like cars driving by, that could potentially result in serious danger and serious injury to that kiddo. And so that would be a permitted use. That's going to be on a spectrum all the way back to, is throwing a pencil across the room? Well, probably not, but if it's a pencil that's about to go into somebody's eye, this is, again, it's too hypothetical and gruesome to think of all the possibilities. And again, hopefully Chapter 33 is going to put a little bit more clarity for folks, the amendments. But it is true. These are greater protections. So restraint and seclusion should not be used as frequently.
We have a question about the time of physical restraint. If it goes beyond 10 minutes and is being monitored every 10 minutes, does it have to stop after 10 minutes, or can it continue as long as it's being monitored?
Under the proposed amendments from DOE, they kept that piece from Chapter 33. The short version is, in the new law, it doesn't talk about minutes or anything. It's more of just the core pieces. And then once it gets into the rulemaking, it appears DOE has proposed keeping those same time periods. And so if it goes beyond 10 minutes, it has to be checked in by the administrator, and then every 10 minutes thereafter, I'm gonna mess it up, but essentially, yes, there has to be constant monitoring to make sure that the restraint or seclusion is being used to the level that's allowed. So is that a continual emergency? Is that still happening? If so, then yes, it can go beyond 10 minutes.
Can you just put the link back up on your PowerPoint for the Maine Safe Schools?
Maine Safe Schools. I'm not sure which one they're talking about. Oh, here we go. Oh, Safe Schools, yeah. Yes, that's the general DOE restraint seclusion site.
So
yeah, you can just Google MDOE restraint. You'll get there pretty quickly. Okay, so I'm going to shift into, we're working towards the end here, just some advocacy tips for folks, and just to highlight what it means when this is happening. And just as an overview, the way that we view it at DRM, and that a lot of advocates and parents view restraint seclusion, is a red flag. Something's not going well. Maybe those individual restraints and seclusions were up to the level and allowed under the law. Yes or no, something's not working. And so it's a red flag. So my immediate default is call an IEP meeting if it's not already on the books, and address it head on. You know, what can we do positively to avoid these things happening? And now under the new law, talk about whether connected to the kiddo's disability, is it something that shouldn't even be on the menu, shouldn't even be possible? So IEP, get in the IEP meeting, get in a 504 meeting, and I'll talk a little bit more about that. And one tool for those groups to use, and you don't have to have an IEP or a 504 for this to happen, but that's a context for it, which is to request an FBA, a functional behavioral assessment. It's an industry standard by which someone, a professional, BCBA or similar, is observing a student, seeing what's leading to the challenging behaviors, and proposing ways to address it. So sometimes it'll be only happening in the afternoon that the challenging behaviors come up, and it's only after math class. And these FBAs can really drill down to what's a precipitating issue and hopefully get ahead of it. Because if restraint seclusion is happening, it's too late. That's the emergency. You need to be back multiple steps, getting ahead of it. Just a little bit more about FBAs, direct and indirect assessments, formulate hypotheses, etc. And then what results from that typically, or should, is a behavior plan, a positive behavior plan, so that everybody's on the same page. So if everyone agrees that after math class in the afternoons, there's something triggering for this student, and we figured out it's the transition down that certain hallway. Okay, well, we're going to support that student further during that time. We're going to bring in an expert to really assess things and go forward from here in a positive way. Try to get some skills instead of the challenging behavior. And then I included some resources in here as well. There's some great letters from the Department of Education, DOE, US DOE, that talk about restraint and seclusion in the context of students with disabilities. And they highlight the fact that it might deny a student the faith. And I would say also LRE, So if a student is restrained or secluded every day, then they're not in an educational setting. They're outside of their program. And so that might not be the least restricted environment for them, let alone whether they're gaining benefit from their education. So this is a letter to look up, take down that citation. It's a great one.
And we're getting a couple questions.
Yeah, please go ahead.
Topic, and it's regarding contracted providers. So a couple different scenarios. Obviously, school systems providers for therapy services or other services, licensed clinical social workers, those things to come into the school.
Right.
Also, for our 3 to 5 year olds right now, a lot of them will go to a special purpose private school. So does the law pertain to those privately contracted providers, and who is responsible for their training and who's responsible for the reporting in those scenarios?
Sure. There's a lot in there. I can only say what I know from what's likely to be held over from Chapter 33, which is that contracted providers are explicitly included. And it's, the overall group of covered entities is funded by DOE, whether directly or indirectly, public or private. And then it says, there's a section called contracted providers, and it says if you're receiving those funds. It's a good question of who is responsible for the training and who's responsible for the reporting and the notifications. I don't know, but someone is. I would think that it's the school setting in which the restraint or seclusion occurred. But that's a great question, and maybe something to propose to be more specific in the new Chapter 33.
Does this also apply to childcare settings, or is this just their school settings?
Well, it depends are they getting DOE funds in some way? So if it's a private childcare for kids 0 to 2, and they're not getting any education funding, no. But if we're talking about like a CDS program, that's funded by DOE. So certainly any CDS funded setting would be included.
Okay, thank you.
Yeah, thanks. Great question. This is very lively. I love it. So just another great resource for families. Another letter, not to be confused with the other 2016 DOE letter, but this one is specific about positive behavior interventions and supports. And it hammers home that same concept, which is if restraint and seclusions are happening, something's going wrong, it might be affecting free appropriate public education. So, they occasionally issue guidance, and this one was to clarify that they need to provide needed behavior supports through the IEP process. And I think this is another quote from the same letter. A failure to provide appropriate behavior supports because they're not offered or because teachers or other staff are not adequately trained that results in the student not receiving meaningful benefit might be a denial of FAPE. So FAPE, again, free appropriate public education. So that's the IEP and 504 world that we're talking about. Just to hit home that one more time, this concept, if things aren't going well, IDEA requires a course correction based on data and experience, and restraint seclusion is a sign that something's not working. And Andrew F., our recent big Supreme Court ruling on special education, stated that doing the same thing and expecting different results is not adequate. Schools have to offer a cogent, responsible explanation for their decisions that shows the IEP is reasonably calculated for the student to make progress or appropriate in light of their circumstances. So,
can you talk a little bit about how a parent can use the IEP process to protect their children from having restraint and seclusion used? And also, I know we hit upon it already, but can you also hit upon it again, the new language in the law about individuals with disabilities and the ability to not be restrained and secluded?
Absolutely. So going back to just some of these recommendations, the IEP and 504 meetings are your friend. And I always recommend families to go into these meetings with a clear plan things written down that they want to have addressed or specific requests that they have. And those things can be, please do an FBA, please do a functional behavioral assessment. We don't understand, nobody seems to understand, the school or us, the family, about why this challenging behavior is always happening at this particular time or place. So we need more information as a team. That's one way, more evaluation. The IEP itself changing, asking for specific things in there, whether it's additional adult support or a change in setting in some way, or needing more access to regular education peers to have better peer examples for them to see. These are all things that parents can advocate for, and please bring along any of these resources I've mentioned, these letters from DOE where they've supported these ideas. Okay, and then there was the other half, Carrie, I forgot.
Yeah, so can parents request in an IEP for restraint and seclusion not to be used against their child or on their child?
Yes, absolutely. That was always true. I mean, families can ask for anything in an IEP meeting. The better question, the underlying part is it reasonable request and will it be granted? Is it likely to be granted? That part, I don't know, but the new law seems to contemplate a situation where you've got a doctor's note. It says the kiddo's disability, they should not be restrained because of X thing, whether it's a physical medical issue or if it's to do with a mental health issue. That would really support somebody's request for that. But ultimately it's going to be an IEP team decision. And if the district says no to the request, the family can pursue dispute resolution if they think that it's not going to provide them FAPE if they're continued to be restrained or secluded. So.
How frequently does an IEP have to be called in response to restraint and seclusion?
So far, again, we can only project what we see as Chapter 33 changes because that hasn't finished yet, and it probably won't finish till February or so. But under Chapter 33, as it's written and as it's likely to stay for these sections, it's I just blanked. What was I was thinking about the time. They don't have, there's nothing in the law that says sorry, yes, I got it.
Meeting has to be called, correct?
Right, yes, after 3, so the number is 3, so after 3,
There's Dan, okay, yeah.
After 3 incidents of restraint or seclusion, an IEP meeting or 504 meeting must occur and talk about whether an FBA is needed, whether it needs to be updated or a behavior plan needs to be updated. And just to highlight another IDEA concept, child find, it's certainly a triggering point too for the schools to say something's not going right, and maybe it's disability related, maybe they need special education. So,
and it should always be pointed out that a parent can call an IEP meeting at any time. So if
absolutely,
a child has never been restrained and all of a sudden, you have one restraint and you're really concerned, you can call an IEP meeting to discuss that. You don't have to wait for your child to be restrained 3 times to discuss that. Absolutely.
Yep. And that's especially true because it is this after 3 times, which, I don't know if that's that effective if a kid's being restrained or secluded every week. 3 times might happen the first week and then there's no more triggering events. So to me, it makes more sense to have a meeting every 3 times but the point is what Carrie said, you can always request a meeting and address in a positive way. Okay, I had just a couple more slides, but do you have other questions in the hopper?
No, somebody was asking a question about the amount of training that our staff gets, and it's, yes, the argument can be made that we need better training in our state. We can't necessarily point our finger as that being the only reason as to why restraint and seclusion are higher in our state, but it certainly is a participating factor. I would make the argument that there are many participating factors as to why our numbers are high, but right now, safety training is what is used as the highest used training in our schools, which does have a de-escalation component as well. but it does train on restraint and seclusion. And there are arguments that can be made that there are better models out there that will assist in giving more information about de-escalating a student, especially with disabilities. I don't know if you have anything to add on that, Ben.
I do. It's gonna go right to my next slide, so it's perfect.
Perfect.
We don't have any specific programs that we promote. I'm sure Maine Parent Federation is the same way. There's lots of things out there. Something might work better for a kid than others, but just one example. It's really the only example that I know of where a Maine school district has spoken about changing the way they approach challenging behavior. And it's MSAD 75, Heidi O'Leary, the director over there. She worked with Dr. Ross Green, which I'm sure folks are familiar with, collaborative and proactive solutions. People know these things, but they implemented it and they saw restraints and seclusions drop down dramatically. So there's just to highlight a quote from Director O'Leary, thinking about the context and changing the paradigm. You know, workers might think initially, well, we can't let them get away with that. They have to have consequences. They're doing it because they're looking for attention. They're just bad kids. And as the new methods start working, in this case, Dr. Green's methods, educators' thinking changes. Johnny gets in trouble every day, walking to the bus becomes Johnny has difficulty walking to the bus after school and when all students are outside. So people start to look at it in a different lens. And just to highlight the data, 75 has seclusions in all of their 8 schools, and they have therapeutic day treatment as well. And they were secluding children 177 times back in 2016 and 100 annually. And then once they started taking a different approach, in this case, Dr. Green's, but could be another one, they saw it dramatically reduced down to 11 for this time period and only 7 restraints for seclusion. So just an example. Again, the only one in the public domain that I know of a director talking about a major shift. And I think it's probably helpful for families to know about that things can be different. And then a link that somebody's already shared, but positive behavior interventions and supports, another approach, another way to address these issues in a school-wide way, and the link to that. So.
Yeah, and I will say that Maine Department of Education has recently received a professional developmental grant. We haven't had one for a few years, and they are continuously funding our PBIS pilot program, which is being headed up by Courtney Polchowski. And I do sit in the stakeholder group, and there's great data coming out of that programming. It's been ongoing for about 5 years now, but Maine Department of Ed has rededicated itself to continuing that project. And they do have great numbers as well on lowering restraint and seclusion in schools. So there's a number of different initiatives that are happening across our state that can make this possible, that we can, really lower these numbers in our state.
Yeah, and that would be great to see too. We should probably reach out to DOE and see if they've got some of that data, just to show folks. Okay, and then the last thing was just some other resources. DRM, me and some other folks have done reports on restraint and seclusion. You've likely seen them if you're aware of these issues, but just highlighting the data and the issues. And then also there's a group in Maine of which DRM and MPF are a part, which is the Maine Coalition Against Restraint and Seclusion, Maine CARS. And they put out a guide as well. So there's a link to that. I'll leave these two up because the last one just says questions, but we're right on the money, right at 1 o'clock. So I want to allow another minute for any questions, Carrie, or otherwise we will let people go.
Amanda was just asking about how to access your services. And I'll say, Amanda, you can always contact me, Parent Federation, as well, and we can get you in touch with Ben. And I know they have another lawyer coming on staff soon as well. But we can put you in touch with Disability Rights Maine. Our phone number is 207-588-1933. And if you give us a call, we can navigate that process with you. There was, there's a concern from the school on that due to involuntary language now being added to the definitions that there is going to be an increase in reporting of restraints, especially at the younger level in our FLS programs, at least until chapter 33 is changed.
That might be true.
I think that's. Michael was asking for links put in the chat. What links are you looking to be put in the chat, Michael? Can you go back a few screens? Oh, okay. Yes, I will put those in the chat. I think that's it for right now, Ben. I will hang out. I will, I have Ben's PowerPoint, so I will pull those links from his PowerPoint and put them in the chat if you want to hang on for a couple minutes while I do that. So when will the changes be made to chapter 33, Ben?
It has yet to be seen. Carrie highlighted the timeline. The proposed amendments are out, and there's a comment period for another month. And then it has to be finalized and then also go to the legislature for review. So maybe February, that's my guess.
That's great.
Okay, I hope it's helpful for everybody. I encourage you to reach out to anybody.
And do you have, they're looking for the 22,000 number that you guys highlighted. I gave them the link to the data page. Do you have the report on your website as well? You have a report about this restraint and seclusion on your website, correct?
Yeah, no, I did see that comment too. And that's the number that's under 2019. So you have to do a little bit of adding up, because the way DOE puts out the data, it's number of restraints, number of seclusions, number of incidents, which is kind of a general thing, and then by the year. So in order to get the totals, you go to the restraints and the seclusions page and add them up. So that's where you get the 22 for 2019.
To provide me with the slides, I'm getting questions about the slides. I put the link, I put the email address in the chat a couple times. He is going to create a PDF of the slides for me and send them to me. Please email Deb Epperson, D Epperson. I'm putting the email in the chat right now at mpf.org if you would like a copy of the slides. And once Ben gets that to us, we will send those to you. But I can't possibly keep track of everybody who's requesting the slides in the chat box, sorry. But if you can please email Deb Epperson at that email address, then we will email you the slides in response. And with that, I think we're good. So thank you everybody for attending and for the great questions and conversation, and enjoy the rest of your day.
Thanks everyone.
Thanks, Ben.